Andariki Shubhodayam. Good morning to all of you. I am going to discuss a citation given by Honorable AP High Court Justice BVLN Chakaravarty. In the case of Srimati Mekala Sudhara prameelalantha, Mekala Sudha prameelalantha Rajahmundry versus State of Andhra Pradesh and another. So this is CRL MP petition number 7676 by 2024, decided on 6/1/2025 by Honorable Justice BVLN Chakaravarty. While hearing a check bounce case, while hearing the appeal on a check bounce case, Honorable Justice observed that the court should try to find out any exceptions are there while awarding the so-called suspension of sentence. You all know 389 కింద వస్తుంది పాత CRPCలో suspension of sentence whenever a person is convicted. If it is below 3 years, then whenever we file an appeal, normally we first request for the suspension of sentence. Here we are going to discuss a check bounce case. In check bounce cases, so definitely if you prefer to go for appeal, you have to pay 50% of the check amount. Sometimes the court will accept 50% also, 20% also. Depends on the discretion of the judge. Important, discretion of the judge. Right, in this Mekala Sudha prameelalantha, she was convicted in a check bounce case. So whenever you hear the word check bounce case, means a case where you have given a check, you have issued a check in favor of somebody, maybe in default payment, part payment of some previous loan or things like that, but it bounces. When there are no funds, paucity of funds, when you reject, so many things will be there. In such a case, they file a case of check bounce under section 138 of the NI Act. Here, same thing happened. Please remember, in Rajahmundry, the check bounce case was for 10 lakhs. The petitioner, that is Mekala Sudha prameelalantha, she was convicted in CC number 551 by 2021. Case is under section 138 NI Act. Punished to a sentence to undergo for punishment of 1 year, and she has to pay the check amount within 3 months, that is 10 lakhs. 10 lakhs is the amount of the check. So normally they go for appeal, suspension of sentence. So here they went to the trial court, appeal number 147 by 2024. The case of, I think, 7th ADJ, somebody, East Godavari, Rajahmundry, because Sessions Court is located in East Godavari also. Then the court allowed the appeal after paying 20%, after asking him to pay 20% of the amount. But agreed by this, he cannot pay the 20% of amount. Therefore, he has approached the Honorable High Court. He said that he has cited a couple of case laws, in which important case law is Jambu Bhandari versus State of Madhya Pradesh and others. I think it's 2021 judgment. So in this case, Honorable Supreme Court of India also held that if there are exceptions, yes, you can allow them blanket order. That means if he is not able to pay that 20% or 30% of the amount, yes, definitely you can allow him. But you have to find out whether he comes under any of the exceptions or not. బ్లాంకెట్ ఆర్డర్ పనికిరాదు, ఇతను డబ్బులు కట్టగలడా లేదా, కట్టలేకపోవడానికి కారణం ఏంటి అనేది తెలుసుకుని, ఎస్ యూ కెన్ గివ్ ఎగ్జంప్షన్. Here he was asked to pay 20%, but he was not able to pay 20%. Therefore, he approached the High Court. This is the thing. Then the judge garu simple ga, without passing any clear-cut direction, orders ఏమి లేకుండా, since he has not stated any condition, I am rejecting. అంటే ఏమి ఉపయోగం? వాడు ఏ ఎక్సెప్షన్ ఏం చెప్పాడు? ఏమీ లేకుండా సింప్లీ డోంట్ రైట్ దట్ ఆర్డర్స్ అని చెప్పి ఆల్మోస్ట్ ఇస్ ద వార్నింగ్ టు ది జూనియర్ కోర్ట్స్, జిల్లా కోర్టు వాళ్ళకు కూడా ఆయన ఒక సొరక అంటించినట్టు. సో ప్లీజ్ రిమెంబర్, ఇక్కడ సింపుల్గా ది పిటిషనర్ డిడ్ నాట్ ప్రజెంట్ ఎనీ సర్కమ్స్టాన్స్ టు get or to justify the exemption for not paying the 20% deposit. So when blanket order is asked, definitely the court has to decide whether the case falls under any exception or not. This is the thing Honorable Justice BVLN Chakaravarty actually emphasized upon. Anyway, since this man is not able to pay that 20% amount, Honorable Justice reduced it to 10%. So asked him, you pay 10%, then the appeal will be allowed. So actually, this is a consideration, good judgment by Honorable Justice BVLN Chakaravarty. The point is, even the judges also should not give the so-called crypt orders. They should give orders with some grounds. So before rejecting the same, they should decide whether this person comes under any exception or not. If so, it has to be made in writing. That's all the Honorable Justice wanted. He did not delve deep into the matter. Only on the technical point he has decided. So all the subordinate courts, as per Article 215 or 226 or 227 of the Constitution of India, the judgment given by the Honorable High Court is applicable throughout its jurisdiction. If you know this much, it is sufficient. Thank you very much.